in your eyes now, but I know there's always a way. From sunrise till dawn I'll be here waiting. From sunrise till dawn I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn I'll be here waiting. From sunrise till dawn I'll never stop. I'll fix you up, make everything look smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
All right. Welcome. Today is Monday, which is Judge David Fleishier's courtroom. So let me get this started here. And let's make this bigger.
Robbins,
Yes.
Ms. Robbins, you are now charged with yet another case.
Predates the prior officer.
How many times she missed court here? Connor, come on up.
Hey, Judge.
I know she's your client, right?
Yes, on the all older case. Yes. So
He just missed once on June.
what happened, Judge, is there was a complaint filed recently about a case that was 2 years ago. And then on that day, we reset her to get her here, and she was unable to make it on that day. And then she forfeited, so then she got rearrested, and then we're here today.
So the possession case was from April, and then right after that one, she picks up a burglar of a motor vehicle.
The B&B is from 2022, but the complaint wasn't filed until one day until the statute of limitations ran.
Yeah, you're right. Have we found probable cause on it? Do you know?
I don't think so, Judge.
So, Ms. Robbins, you're charged with two cases. You're charged with burglary of a motor vehicle. You're also charged with possession of a controlled substance. You're facing a year in jail and or a $4,000 fine on both of those cases. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am.
This is where the story of Warborn begins. And this is the war of ours.
So I guess start with the burglary case, if you don't mind.
Officers conducted a follow-up investigation and found that on May 23rd, 2024, the defendant had been identified as entering the complaining witness's car without her consent. Officers spoke with the business owner, who provided a video and photos of the incident, which were then matched with the defendant's Facebook photos. which was provided by the complaining witness. The video showed the defendant entering the passenger side of the complaining witness's vehicle, removing items and getting into another car. And I apologize, Your Honor, it was wrong date in the summary, but it's 2022.
So that is because I was, okay. Did they get the property back? Now, can we go ahead on the other case? Do you mind?
Officers conducted a traffic stop in Harris County, Texas, because the vehicle had a headlight out. The officer asked the driver for consent to search the vehicle. Consent was given. While searching the vehicle, the officer located a black purse that belonged to the defendant, who was the passenger of the vehicle. The officer asked the defendant for consent to search the purse, and the defendant gave consent. Upon searching the purse, the officer located a Rexall pill bottle that contained 2 white pills that had the imprint of M367 on it. The officer, from his training and experience, identified the pill as hydrocodone pills and detained the defendant, and the total weight was 1.3 grams.
And I'm going to find that there's probable cause to go forward with both of your cases. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication, and not to be in, and not to have any contact with the complaining witnesses in the burglary case. Do you understand your conditions? If you violate these conditions, if you consume alcohol or dope, I'm going to put you in jail. If you show me that you can't stop, I will put you in a rehab facility. Do you understand? So you can either do it your way. If that doesn't work, we will do it my way. And I promise you're not going to like the way that I do it. Do you understand?
Just for reference, what is the name of the complaining witness?
It is James Whitehouse.
So Tracy, if you can do the conditions on the burglary case, please. No weapons, no alcohol, no drugs, no contact with the complaining witness. Ms. Robbins, it is your responsibility to stay in touch with Connor. He will tell you when you have court. I'm not going to put up with any flight. You take off on it, you don't show up again. You will be, you will not get any more PR bonds. You understand, man? The only thing we're asking you to do is come back and stay out of trouble and don't use anything you're not supposed to use. All right. For now, I'm going to have you go to Victoria. We'll have you sign a reset, and then you'll meet with Tracy for your bond conditions. All right. Thanks, Connor. Ms. Yonker, you had an assault family member with us. You've now picked up the violation of a protective order, and they filed it as a felony. You're looking at 2 to 10 in the penitentiary. I don't know what happened. I'd like to know. That's why I brought you out, because you're still on bond in our case, and I want to know whether that could be yanked or not. I don't know what happened, but can you please?
HPD was dispatched just before 1 a.m. on July 4th to the Belfort condos in Harris County, Texas. The complaining witness is the defendant's former boyfriend. The complaining witness has a protective order prohibiting the defendant from having harassing or threatening contact with him and prohibiting her from being within 200 feet of the defendant's residence at Belfort. The complaining witness states that the defendant showed up at his home and began kicking and banging on his door for approximately 3 minutes. When officers made contact with the defendant, she stated she had come to pick up her belongings. This is the second violation, and the defendant had previously returned to the complaining witness residence on July 2nd.
So they caught her at the place? Do you know or no? No. Point, Ms. Yonker, you're going to get it. You can't just continue to do what you're doing. That's why we have, fun. It's not, but I'm now going to revoke your bond in our case as well. And I'm going to raise it up to 5,001. First, I would have you talk to Carl to see whether that's something that you should, because I don't want you to say something. I've got a bunch of DAs here, Ms. Yonker, and I don't want you to say something that's going to further, case as it is.
Your Honor, if I may.
Of course.
Ms. Yonker, I visited with her when I was assigned to her case. I told her, and she understood not to go over there to her residence without escort by police authority to get her property back. However, she did text me and call me a couple of days thereafter telling me that Mr. Stone, who's the complaining witness, had thrown her property or belongings in the Dempsey dumpster nearby and that she couldn't come and get it. She apparently did go by there to try to get her property back on the July 2nd date, which is about the same time period that we're talking about. he received text or phone call from a third party to go by there to get her belongings. And that's when
No one can authorize you to violate this.
he can't, and the only.
And what is so, property is so important that you're willing to risk going to jail and up to 10 years? Have some kind of disco ball that's made of gold? What's so important?
I put this in my ears, and I haven't asked anyone to repeat themselves in over 3 months. This is magic. I wish I tried.
The thing is, but I was under the impression that the cops were there and he said.
I mean, that poof and magic, the cops are just going to show up. You know what they say about assumptions, Ms. Yonker? Unless you call them and make an arrangement for them to meet you there, they're not going to magically appear like.
Hours for them to come to me, and I almost stepped in jail. I need all the cop cams of everything pulled. I don't know why the ending of the report doesn't tell you what really happened when I pulled up to the thing with him, because he called me and told me that I could.
Not even supposed to have contact with him.
Yes, sir.
I told you, if he calls you, hang up. If he texts you, do not reply. We tell you these things to put you on notice of what you can and can't do.
Yes, sir.
At the very minimum, you could have called a friend and had them go get the stuff for you if it's that important to you. And now, do you have anyone that's going to post the money for you?
She's got a $30,000 bond for felony court, so I don't anticipate, I don't any contact with several people, that nobody will come in and post a $30,000 bond.
I was out on bond, and he hired my bond yesterday because I don't ever.
Isn't she from you're from another state as well, right?
No, she's from-
Because of him.
Jefferson County is kind of another state almost, but not quite.
Yeah.
Oh, aren't you not from another state or
She's from
something?
Beaumont.
But I talked to court when everybody was talking, so he raised my bond. I didn't know if this was a charge because I was asking a question, because at the end of the report it doesn't say everything that really happened, because I was not caught on the
It
property.
doesn't matter. That's the thing. You cannot justify violating a court order. You either do or you don't.
Yes, sir.
That's it. So I'm going to revoke it, sitting at 5,001. If you're able to make the bond upstairs, or if they reduce it or something like that, come back and talk to me. But I'm issuing a protective order now, right now. I want you to understand, if you violate this, or if you violate this now, they will hold you at zero bond. No bond. Would be very, very careful. Means no, Ms. Yonker.
I understand.
I hope you get it now.
I didn't with the felony charge.
You're going to revoke it, you raise it only to 1,000, as opposed to 5,000, because she already has a $30,000 bond.
I'll do 2,501.
Thank you, Judge.
And then you let me know if she's,
We need some relief there after if she's able to give some relief with the felony.
I'm not happy with you, Ms. Jackson. You have a bond violation. You were ordered not to consume alcohol. You were ordered to get a device and blow into the device, and you're trying to fool us. What's this look of bewilderment that you have? Mr. Slider?
Judge, I met with Ms. Jackson yesterday. She's acknowledged that she made a few mistakes. Wants court to give her another chance. Says she will comply with the rules of the monitoring.
Her attitude tells me something completely different.
Let her just tell you directly.
No, sir. I think what I explained to my attorney yesterday is I believe that I may have a problem and I didn't get the opportunity to need additional support. I acknowledge that.
So something has to change, because what we're doing now is not working.
Sir,
So what has to change? What are we going to do?
I need support. I need to go to some type of meetings in order to help me with my urges, honestly. I'm a single mother. I do things. I recently just moved. I said I've been trying to grow in my life, and in that I've been stressed a little bit, and that's what's causing me to consume.
How many kids you got?
I have one child.
How old is that child?
He's 9.
How old that child?
Me, full custody.
What happens if you go to jail?
His father would take him. I don't think he would like that, though.
Well, let me ask you this. Do you get along with the father?
I do.
Do you have a custody support arrangement or
So
what?
we just co-parent.
I advise her maybe start trying to go to AA.
No, it's not going to start. It's going to happen. And I want 90 AAs in 90 days. And I'm going to bring you back in 2 weeks. And I want to see that you've got 14 done. And if you don't have it done, guess what's going to happen?
Oh, yeah.
Correct. And I'm now modifying your conditions. I'm giving you 1 day and I'm going to put an ankle monitor on you so I know that you're not consuming alcohol. I'm going to modify the conditions, put a scram on her ankle so I know that she's not trying to fool us again. Ms.
She'll turn in
Jackson.
the current flow device and put the scram.
Correct. If you fool me one more time, if you try to play me for a fool, you will go to jail. I will not give you any more chances. The only way that you will remain out now is if you're doing AA classes on a daily basis to prove to me that you're trying to take a proactive approach to staying sober. But the next time, you will go to jail. I will hold you in contempt, slap you with 180 days, probate it for 2 years, and put you in a rehab facility. And I'll do it in a heartbeat. Do you understand, Ms. Jackson?
Yes, sir.
That's what you have waiting for you. If you don't care where you come up here and try to say where the alcohol came from, I don't care if it's a tequila lollipop, a buccal swab. I don't care if it's isopropyl, hair dye. I've heard it all, and I will not entertain any excuses from you. Mouthwash, I don't care. Do you understand?
Yes, sir.
So let's reset this thing 2 weeks from today. She has 1 day to get these, or she has until Monday to get the scram device on her ankle.
The court will pay for that, Judge.
Of course.
Thank you.
Thank you, Your Honor.
Can you excuse, Judge?
Sure. Good morning, Ms. Roberson. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed.
On July 7th, 2024 at 3:30 a.m., officers were dispatched to a traffic hazard call. Upon arrival, we spoke with a witness who said that he saw the defendant in the front driver's seat of the car. He was traveling northbound on West Loop North Feeder, and her vehicle was parked in the middle of a moving lane of traffic. He got out, he called to check on the driver, and she was in the driver's seat, engine running. The front passenger side of the defendant's vehicle was inoperable, and officers observed an odor of alcohol on the breath and the defendant to have poor balance. Officers observed dash cam footage from the witness, which showed the defendant's vehicle and the defendant exiting the vehicle. The defendant's demeanor was angry and she had bloodshot eyes. Officers spoke with the defendant, who said that she was traveling home from a restaurant. Standard field sobriety test was conducted, 6 of 6 on the HGN, 6 of 8 on the walk and turn, and 4 of 4 on the one-leg stand. The IC was read, breath was declined, and blood was drawn pursuant to a warrant.
Was there an accident? I don't, just stopped in a moving lane of traffic. Was she, wait.
Not clear.
Yeah, it's the way they wrote that report was like being in a drive-through.
Same questions I had. And when officer arrived, she was not inside the vehicle, Your Honor. They're basing the will witness on this witness that called and asked for the officer to be.
Find something differently. You can always reapproach on PC.
I will, Your Honor.
Happy to do it.
You know I will be also, Your Honor.
So, Ms. Roberson, find probable cause to go forward with your case now. Do you have a Texas driver license?
Yes, sir.
Do you have valid liability insurance in your name?
Yes, sir. It's in my mom's name, my insurance.
Not in your mom's name. You have to be named on the policy.
Yes, sir.
If you are not named on the policy where your name actually is listed and which car you're protected with, you're not allowed to drive, man.
Style starts with the details. The difference between mid and next level, a real gold chain.
Until I know that, I'm going to bar you from driving. If you can show me today that you're listed as on the policy, then I'll allow you to drive. So it's very easy. All you have to do is go to an app or the website and find out. So I am ordering you not to consume alcohol or illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of dope, I will revoke your bond, put you in jail. You will not get any more PR bonds.
And Your Honor, if I may, she lives in Dallas. She was just down here working for the weekend. Is it possible we can just do test only when she appears?
No, not for now.
Rather than random?
What we'll do is you will be called for random testing. You must go to a Quest diagnostic, get the test done there, get it to Brock, and he will get it to us. If you just blow us off, I will issue a warrant for arrest. But going to a Quest, so I'm making it to where you don't have to come back to Houston to test. I will waive your appearance, so you don't have to waste your time coming to court, but you have to stay in touch with Brock.
Yes, sir.
And when you do get called for a test, go to a Quest diagnostic, test there, the result to them, and then that'll satisfy us here. Any questions? For now, have you signed an affidavit that you're not to drive? After that, we'll get you to Victoria, sign a reset. After that, you'll get a trace of your bond condition. After that, you're free to go. If you show me that she's got insurance, then I'll rip up the affidavit.
I have it to you, if not today, by Monday at the latest. So thank you, Your Honor. Have a great day. Bye. Be.
Why are you laughing?
It's not the same as coming home.
Every day in Harris County, someone dies from a DWI, Mr. Asik Chen. Every day, someone dies from a DWI. And here you are with 2 open DWIs. What on earth gives you the right to endanger my people? All you have to do is stay home. And if you'd stay home, if you must get out, take a freaking Uber or walk. Now you will learn the hard way because you will be deported. In life, when you do things the right way, you are rewarded. For you, that means wherever you get deported to, if you want to come back to the United States, ask for permission first. Because if you come back without permission and you are caught, you will be facing 5 years in minimum in a federal prison. And if you thought this was bad, wait till you get to federal prison. Because I'm going to tell you, with both of your DWIs that you have now, if a police catches you, they will be chomping at the bit for you. All we want are our streets to be safe. I'm not asking for much. You've worked out an agreement now where they're going to dismiss one of the DWIs and you are pleading to the other one. Understand from now on, if you are ever in a car and you get stopped, the first thing an officer will do is they will look up your criminal history. They will look to see that you have at least 2 DWIs on your record. Do you think that they're going to be nice to you? No. Right. They'll never be nice to you from now on. And that's because of your criminal history. Never, even if you've had a sip of alcohol, don't get into a car and drive because you will be right back over here. From now on, you'll be facing a minimum of 90 days in jail. And every time you go to jail, you will get an ICE detainer. Don't get into a car. You give up the right to a trial, right to compel witnesses to testify on your behalf, front and cross-examine your accusers, the right to be arraigned, charged, read to court. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, this will go on your record. You can never take it off. Do you understand?
Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty? Is it or untrue that you had a 0.15 or above, Mr. Asik Chen? Okay. Which one are we on, the first one or the second? And then the other one will be dismissed. Okay. How do you plead offense, Mr. Asik Chen? Guilty or not guilty? I will find you guilty. I will send you to 3 days in jail. I will give you credit for 1, although you have many more days. He's got many more. But I'm going to suspend your license for 2 years. I'm sorry, for a year. Do not drive until you get a license. Ask for permission before you come back to this country. Otherwise, you can be doing many years in federal prison. Good luck. Thanks, Ruben. Thanks, Ruben. Ronaldo Perez, what have you done now? You've picked up another case. You were on bond for theft. You've now picked up a Class A driving with a false ID or a false license.
The police don't want you to know this, but the reason we always ask for your insurance is because we know with the cost of everything rising.
You're facing up to a year in jail and or a $4,000 fine. And this is your second fraudulent identity case. So we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you, sir.
On July 5th, 2024, officers conducted surveillance on the defendant who had a felony warrant for fraud use of identifying information. Officers contacted him to inform him that another officer would meet with him regarding an unrelated incident. Plainclothes officers observed the defendant waiting in the parking lot. Uniformed officers met him and asked him for his identifying information, and he presented a Dominican passport with his name, date of birth, and photo. Officers detained him and searched him, and an inventory search turned up a wallet, keys, 2 phones, and a Texas driver's license with the name Aurelio Valdez, date of birth 7/20/1993, and a credit card that did not belong to him. The credit card had a common name and the bank was closed down. The driver's license had no watermarks, blurred font / photo, and no holographic images, no mini photo, no ghost image of the Lone Star State symbol, and the defendant had his own photo on the card. Defendant said that he uses the ID for work.
Perez, I'm going to find that there's probable cause to go forward with your case. And now I'm going to revoke your bond on your first case, and you will be staying with us. Goes with you. Are you Mr. Rivera Araujo?
Yes, sir.
Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
July 6, 2024, at 10:30 p.m., officers were investigating a parking lot takeover in a strip mall parking lot.
200?
Participating in the parking lot takeover, officers observed a white Ford Mustang perform 2 to 3 donuts inside the parking lot and burn out within 5 feet of a large crowd. Officers conducted a traffic stop and identified the defendant by his Texas driver's license. Stated he performed the action because he was at the car meet, and he also had a front passenger.
Mr. Rivera, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen?
I am resident. I have the green card.
You have a Texas driver license?
Yes, sir.
Do you have liability insurance in your name?
Yes, sir.
Okay. I'm now use the condition of your bond not to participate in any more street takeovers, donuts, reckless driving, burnouts, racing, whatever it may be. If I find that you participate in this kind of action again, I will revoke your bond, put you in jail, and take your driving privileges away from you permanently. Do you understand?
Yes, sir.
No more. Can you file those conditions, please? Okay. We have to reset your case to give you time to hire a lawyer, Mr. Rivera. I will do everything in my power to protect every single person of Harris County, Mr. Rivera. If that means putting you in jail because you continue to do foolish things on the road, so be it. I have no problem setting your bond extremely high. Go to Victoria, sign a reset. After that, you will take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free on your way. Is it Velasco Perez, Victoria?
Page 31, Morales.
No, yeah, sorry, that's it. Let's just do this one and we can look it up in a minute.
Okay.
You ready? This is Velasco Morales. Mr. Velasco Morales, you were charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford one, one will point it to you, sir.
On July 7th, 2024, at 2:39 a.m., a witness flagged down an officer regarding a vehicle stuck in a drainage ditch. The vehicle was inoperable and had front engine. The vehicle was running but in park. The defendant had slurred speech, blocked eyes, and odor of alcohol on the breath, and he admitted to operating the vehicle. The defendant was in possession of the keys and ID as the defendant by his previous mugshot. While detaining the defendant, an off-duty sheriff spoke with officers and stated he observed the vehicle pull into the mud district building driveway before slowly rolling into the ditch. The Defendant admitted to having two 24-ounce Coronas at his house and was on the way to get tacos. Standard field sobriety test was conducted. HGN was a 6 of 6. Walk and turn was a 6 of 8. One leg stand was a 2 of 4. DIC was red. Breath was a .194 and a .198.
Ready to be on? Looks like he just has a prior evading arrest. For Velasco Morales, I'm going to find that there's probable cause to go forward with the case. Tell me, are you a United States citizen? Are you in this country with or without permission?
With permission?
What type of permission? What type of?
Work.
Simple. I only pay $10 a month for my internet connection. Fast, unlimited, anywhere. Have you heard about Ryoko Pro?
La Servención. Understand, it can be revoked at any time. The more criminal cases you pick up, the higher likelihood you have of that happening. Do you have a Texas driver license?
Texas? Yes.
Can you run his license, please? I'm ordering you now as a condition of your bond not to consume alcohol, legal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of dope, I will put you in jail. You will not get any more PR bonds. Do you understand, sir?
Yes, sir.
I don't know if you have permission or not. And quite frankly, it doesn't matter to me. The only thing that you need to understand is that if you go to jail and there's any problem with your immigration paperwork, they will put a detainer on you. You will be stuck in jail until everything is over. That means you'll sit in jail for at least 9 months. If you do not want that to happen, don't violate these conditions. I'm going to have you go to Victoria, sign a reset. After that, you'll get with Trace for your bond conditions, then we'll get you out of here. When you come back, please have a lawyer, sir.
Logan was unable to see driver's license for the defendant.
Okay, let's just have him take you to the jury box for now. Stephen, in the jury box. Stephen, is it Mr. Asamoah? Mr. Asamoah, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
On July 4th, 2024, officers conducted a traffic stop on a vehicle who ran a red light. They observed the driver to have red glossy eyes and the smell of marijuana. The defendant admitted to smoking marijuana and said that he left a pool party and was going to a liquor store to buy alcohol. Standard field sobriety test was conducted, 0 of 6 on the HGN, 5 of 8 on the walk and turn, and 3 of 4 on the one leg stand. The officer was also a certified A-ride and conducted an A-ride test. He stimulated 30-second counts. Defendant correctly estimated 30 seconds but swayed at 12. The defendant's eyes did not converge on the lack of convergence test. The modified Romberg, the defendant's eyelids trembled, and finger to nose, the defendant was unable to consistently touch the tip of his nose with the tip of his index finger, touching instead his upper lip and above his nose. The defendant stated he was a 3 or 4 out of 10, with 10 being completely high, and stated he would still be comfortable driving a school bus of kids in his case. He was red. Blood warrant was executed and blood was drawn.
So they did the DRE then. Any prior DWIs? Mr. Asamoah, how old are you, sir?
19.
What do you do for a living?
Right now, just trying to work to go to college.
Did you graduate high school?
I graduated.
Okay. It's time for you to do something. You either need to get a full-time job or get into school full-time. I'm not going to let you be out here doing nothing all day, smoking weed and playing Xbox. Do you understand?
Sure.
I'm going to test you 30 days from today. You test positive for marijuana, what do you think is going to happen? Right. As long as you stop smoking as starting today, you will be fine in 31 days. You'll notice that you will get tested. That's it. There's no excuse. If you hang with dogs, you're going to get fleas. I will not accept the excuse that, oh, I'm in a car and there's other people smoking dope and I didn't smoke. I don't care where you're going, who you're with. You test positive, you're going to stay with me. I will have you apply for an appointed lawyer today, Mr. Asamoah. And then what I'm going to do is I'm going to bring you back in 2 weeks. And I want you to show me what you have done to get a full-time job. If you've done nothing, life's not going to go well for you. Do you understand, sir? Okay. I order you not to consume alcohol or illegal drugs. I will randomly test you. You test positive for alcohol. Likewise, I will put you in jail. You will not get any more PR bonds. That's it. You have a Texas driver license. You are not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive. The worst possible thing you can do in this short life is get in a car and drive, because you do, facing a contempt hearing, up to 6 months in jail and a $500 fine every time you drive.
Hold on. I hate that.
So we give him an application, deputy, please, for an appointed lawyer. So first we get 2 weeks back, and then another 2 weeks after that to come and take a drug test. And then I'll make a notation now so we don't forget. Morning, Mr. Madexo. You're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. They can or will use against you. Right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
On June 30th, 2024, officers responded to an intoxicated person call for service where the defendant was taken into custody for public intoxication. While the defendant was being transported, he became belligerent in the backseat of the marked patrol unit by screaming and kicking his feet against the partition. The defendant proceeded with erratic behavior and slammed his head against the partition, causing a laceration on his forehead. The officers removed the defendant from the backseat of the patrol unit to help prevent further self-harm, and the defendant, who was placed on the ground, proceeded to actively resist arrest by repeatedly kicking his feet and rocking his body side to side, making it difficult for officers to control. During that time, one of the officers performed a wrist lock technique in an attempt to control the defendant. The defendant continued to resist, causing injury to the right ring finger of the officer as it got trapped between the defendant and the ground. An additional assisting unit arrived and police were able to restrain the defendant.
Sir, I'm going to find that there's probable cause to go forward with your case. You know, a lot of priors. I wonder how many of those priors are related to just that very fact of alcohol and or dope, you know? Some people, when they get lit, they become happy like little bunnies jumping in the woods. And then there are those that turn into what? Right. You got to be careful, man. Life's way too short. Just
2 more days, know that I would have been in rehab. I was already volunteering to go into rehab so I can have housing.
It's always a shoulda, coulda, woulda. Now is the time, though, Mr. Madexo. It's going to happen now. No more alcohol, no more dope. Do you still want to do that?
Yes, sir. It's in court. It's in your court.
I want to see it happen.
Yes,
we're
sir.
going to either do it your way or we're going to do it my way. And I promise you, you're not going to like the way that I do it. I will give you the one opportunity to do it yourself. And I'm going to tell you now, if it doesn't happen, we're going to do it my way. You're not going to like my way. You understand? I'm going to give you a lawyer today, and we will work out how we're going to do the logistics today. No more alcohol, no more dope. You understand, sir? Now, I don't think he's on probation, right? Did he get early terminated from that probation? I'm sure he's on deferred for building, but I think he may have gotten
terminated, Judge.
Okay, that's the thing.
I don't know why it stays on there like that.
The problem is the more you get into trouble with law enforcement, the more they're going to harass you and harangue you about it. You know what I mean? So look, I'm going to give you a lawyer today. Let's figure out how we're going to go from here. No more alcohol, no more dope. Okay. Sorry about it. Okay. Let's just, I'm going to have you first go to Victoria, sign a reset, and then I'm going to have you take you to the jury box while I find you someone. Okay? All right. Mr. Sager, sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one to you, sir. Okay.
On July 7th, 2024, at 1:25 a.m., officers responded to a minor accident call for service and met with a complaining witness who was stopped on one of the eastbound main lanes of the East Freeway. As the complaining witness was stopped, the defendant struck her from the rear on the left side of her vehicle. The complaining witness advised she saw the defendant drive and he was the sole occupant, and she saw him exit the driver's side door. Witness advised that the defendant began to apologize to her, and during the conversation he mentioned he was intoxicated. She recorded a voice memo of this. Officers observed the defendant to have a strong odor of alcohol on the breath, wet red eyes, and refused to answer any questions or participate in the standardized field sobriety test. The IC was read, blood warrant was obtained, and blood was drawn.
See if he has any prior DWIs, please.
Yes, sir.
Sager. Mr. Sager, I'm going to find that there's probable cause to go forward with your case. Do you have valid liability insurance in your name? Okay, as long as you have that and a license, you can drive. No more alcohol, no more dope. I'm going to randomly test you. If I find that you're consuming either, I will put you in jail. No more PR bonds for you. We're going to reset your case to give you time to hire a lawyer.
Your $200 puffer keeps you warm at the coffee shop. But as soon as you step outside...
So I'm going to first have you come up to Victoria, sign a reset. After that, you'll eventually get location and bond conditions, and after that, you're free to go. Don't pick up any new cases. Don't drive unless you have a license and insurance, and above all else, no alcohol, no dope. You understand? Okay, come on. Good morning, Mr. Slater. Sir, you're charged with 2 cases. You're charged with possession of marijuana and unlawful carrying of a weapon while intoxicated. You're facing up to a year in jail on the intoxication case, and you're facing up to 6 months in jail on the weed case. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On July 5th, 2024, officers conducted a traffic stop for an expired registration sticker. The vehicle was slow rolled until it came to a parking lot of the Shell gas station. Upon contact, officers smelled the odor of marijuana and gray smoke emit from the vehicle. The defendant was the driver. A probable cause search located a black Ruger pistol behind where the radio screen is. The gun was loaded with a bullet in the chamber. In a small storage bin under the steering wheel was 13.37 grams of marijuana in a saran wrapped bag. And the defendant admitted to owning the pistol, but said he did not know there was marijuana because it's his girl's car.
He's driving? So you charge him with unlawful carrying of a weapon while intoxicated, but he's not charged with the DWI, and he's charged with the weed. What's the sense in that? Did you see this? Look at Swayzer. It's okay. He's in a car.
Okay.
He's driving.
Okay.
They charge him possession of marijuana. They charge him with unlawful carrying of a weapon while intoxicated, but it's not a DWI. I don't understand. I mean, how do we get how they find intoxication?
There was no standardized field.
Judge, we charge him with the UCW while possessing marijuana. If you look at the charging instrument, it's just straight UCWs. We didn't charge him. I know it's titled that in the thing, but if you look at the charging instrument, it's just.
Because it shows here while intoxicated.
Yeah, it's showing like that on my end, but the charging instrument itself is straight UCW. So,
I can't get anything to work. Is yours? Is Dean's down for you? Can you pull up the charging instrument? Because I can't pull it up here on Swayzer. On the intoxication. Mr. Swayzer, the system's not working, and I want to make sure that we don't overcharge you. So for now, just take a seat for me in the juror box. When I get it working again, I'll pull you back out. Sir, you're charged with driving while intoxicated, facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On July 6, 2024, officers were dispatched to a traffic hazard regarding a stalled vehicle on Broadway. Upon arrival, officers met with a witness who stated he called 911 as he found the defendant passed out behind the wheel of a vehicle. The witness advised that the defendant was in the driver's seat and the sole occupant, and the keys were in the ignition and the car was on. Officers woke the defendant, and after the defendant exited the vehicle, officers observed a strong odor of alcohol on the breath. The defendant stated he drank 3 Coronas. Standard field sobriety test was conducted. HGN was a 6 of 6. Walk and turn was a 0 of 8. One leg stand was a 0 of 4. PIC was read, breath was refused, and a blood warrant was executed and blood was drawn.
Sir, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen? Are you in this country with or without permission? What type of permission do you have?
Resident?
You are a resident.
Yes, sir.
But you still don't have a Texas driver license. You do have a license. Do you have liability insurance in your name?
My father.
Okay. Before we allow you to drive, Mr. Landaverde, I want you to 100% be sure that you have insurance. Mr. Reyes, do you mind checking to make sure that he's covered? If you are covered under the insurance, I will allow you to drive. Understand, you are not a citizen. The more criminal cases you pick up, the higher likelihood you have of that residency being revoked. They can revoke it at any time. The more criminal cases, the more likelihood that's going to happen. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that that you're consuming alcohol or doing anything you're not supposed to, I will put you in jail. You're not a United States citizen, and I don't know if you're a resident or not. But if there's any problem with your paperwork and you go to jail and immigration finds you, they will put a detainer on you, sir. So I would be very careful. I will waive your appearance, but you must stay in touch with Mr. Reyes, and he will tell you if and when you have to come back to court. You understand? If he tells me that you're playing games, that you're not responding to phone calls or text messages, I will issue a warrant for your arrest. Okay, I'll have you go to Victoria, sign a reset. After that, you'll get retraced for your bond conditions, and then you're free to go.
Thank you very much, Your Honor. Have a great day.
You too. Franklin Koch Tambriz.
Hey guys, this is Senator John Ossoff in Georgia, and please hear me out because I'm the only Democratic senator.
Yes.
Sir, you're charged with driving while intoxicated. You're facing up to a year in jail because of the high blow. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On July 4th, 2024, officers were dispatched to a crash call. They spoke with a witness who advised that the defendant ran the red light and struck her. Witness observed the defendant get out of the driver's side door after the collision, and officers made contact with the defendant and observed blood.
It's too loud, please.
The officers observed the defendant to have bloodshot eyes, slurred speech, and a strong odor of alcohol on the breath. The defendant admitted to drinking 2 Modelo's. Standard field sobriety test was conducted, 6 of 6 on the HGN, 2 of 8 on the walk and turn, 3 of 4 on the one leg stand. PIC was read, breath was consented to, and it was a .168 and a .160. The defendant was ID'd by his Guatemalan ID card.
Do you have any prior DWIs? Any other criminal history? Okay. Mr. Tambriz, I'm going to find that there's probable cause to go forward with the case. What happens if you go to jail?
I wouldn't like that.
What do you say?
I wouldn't like that.
Don't tell him. I want him to think, Robert. What happens if you go to jail, Mr. Koch Tambriz?
I have family.
Look at me. What happens if you go to jail? Piense. What happens if you go to jail? Any idea how long you will sit in jail waiting for immigration to do what they're going to do? Take a guess. How long you'll sit there? You will be there for a minimum of 6 months. So if you have anyone here that depends on you, it's not going to happen. They might look to other people, other places that you may not like for support if you're gone for 6 to 9 months in custody. I'm putting conditions on your bond now, Mr. Koch Tambriz. Do not violate these conditions. This is the only warning that you're going to get from me. You violate these conditions, I'm going to put you in jail. And if you're unlucky enough, you're going to be there for an extremely long time. Do not drive. You do not have a Texas driver license. Therefore, you may not drive. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. It is your responsibility to stay in touch with Mr. Gallegos. He will tell you when you have to come back to court. Mr. Gallegos tells me he can't get a hold of you because you're playing games. I will issue a warrant for your arrest likewise. Do not drive, do not drink, and stay in contact with your lawyer. You understand? There's no excuse. All you have to do is show up and don't drink and don't drive. And good things will happen for you. I'm going to have you come up here. You will swear to us that you're not going to drive. After that, I'm going to get you to Victoria to sign a reset. You will then go to Tracy, where we'll have you sign your bond conditions, and then you'll be on your way. This is the only friendly warning that you're going to get from me, sir. Take it how you will, but you will not get another one. Come on. Thanks, Robert.
Raymond, and this is Herman's case. I'm here for him because he's out of town.
All right. Are you Mr. Juarez Chavez? Mr. Juarez Chavez, you're charged with driving while intoxicated. Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On July 6, 2024, at approximately 1:14 a.m., officers conducted a traffic stop on a truck crossing the lane divider. Defendant was ID'd by bloodshot eyes, slurred speech, an odor of alcohol on the breath, unsteady on his feet, and the defendant was swaying. Standard field sobriety test was conducted. HGN was a 6 of 6. Walk and turn was an 8 of 8. One life seen was a 3 of 4. Before securing the defendant in the backseat of the patrol vehicle, they discovered 0.35 grams of a white powdery substance, cocaine in a small plastic baggie in his right front jeans pocket.
I don't see that they've charged him yet with it, I guess, huh?
And then
PCS and yes.
Angel Juarez Chavez.
Oh, okay. Sorry, looking at Juarez Hernandez. This is Juarez Chavez. Sorry. I see it. Okay. Yep.
He was read, defendant consented to breath, and it was a 0.243 and a 0.237.
Ready to be honest. Okay. Mr. Juarez Chavez, I'm going to find that there's probable cause to go forward with the case. Tell me, are you a United States citizen?
No.
Are you in this country with or without permission?
Without.
What happens if you go to jail?
I don't know.
Think. What happens if you go to jail?
Go to Mexico?
You know how long you will sit in jail for immigration to do whatever they're going to do? You will sit there for about 6 months at a minimum, perhaps 9 months, perhaps a year, waiting for immigration to do whatever they're going to do to you. You were lucky to get out of jail one time. If you press your luck, you go back for any extended time whatsoever. Immigration will put a detainer on you. You will be stuck like Chuck in jail until all these cases are over with. And I'm going to tell you now, nothing fast happens in Harris County except resets. Do you understand? I'm putting conditions on your bond now. You violate these conditions, I'm going to put you in jail. And if you're unlucky enough, you're going to be there for an extremely long time. You do not have a Texas driver license, so I'm ordering you not to drive whatsoever. You will be signing an affidavit with me today promising me that you're not going to drive, and I don't care what your excuse is. I don't care if you need groceries, there's a burning building and you have to save a cat. I don't care. You drive, I'm going to put you in jail, and you may be there for a long time. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. You will be called upon to come and provide a sample to us at some point. If you blow us off, you will go to jail, Mr. Juarez Chavez. Don't push your luck again. You have a lawyer. It's your responsibility to stay in touch with them.
Style starts with the details. The difference between mid and next level, a real goal.
They will tell you when you have to come back to court. If they tell me that they can't get a hold of you because you're playing games, I will issue a warrant for your arrest. Understand me? Do not drive, do not consume alcohol, illegal drugs, and stay in contact with counsel. You will not get another warning from me. So take it how you will. We'll have you come up here, swear to us that you're not going to drive. I'll get you to Victoria to sign a reset. After that, you'll get for your bond conditions, and after that, you'll be free to go. Ask him. I don't know. But that's why he makes the big bucks. You, Jocelyn Juarez Hernandez. Ma'am, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas if you cannot afford a lawyer. A lawyer will be appointed to represent you, ma'am.
July 6, 2024, at 1:51 a.m., officers conducted a traffic stop on a vehicle for running. Officers made contact with the driver, who identified herself by her Mexican passport. Officers observed a strong odor of alcohol on the front. She said that she had 2 Michelob Ultras before driving. Standard field sobriety test was conducted, 6 of 6 on the HGN, 2 of 4 on the one-leg stand, and she refused the walking tour. DIC was red, BAC was a .165 and a .165.
Guys, no criminal history or what?
No criminal.
Mr. Hernandez, I'm going to find that there's probable cause to go forward with your case. Tell me, how old are you, man?
23 years old.
What do you do for a living?
Cleaning houses.
Are you a United States citizen?
Still in the answer? No.
Are you in this country with or without permission, man?
No permission.
What happens if you go to jail?
What would happen?
Happens if you go to jail?
I don't know what happens.
I'm going to ask you again, are you in this country with or without permission? What happens if you go to jail?
They would send me to Mexico.
Right. You will get an ICE detainer. You will sit in jail until immigration is done with you. It will take 6 to 9 months for them to do anything that they're going to do, and you sit in jail waiting for that to happen. If you do not want that to happen, do not violate these conditions that we put on you now. If I find that you're consuming alcohol, I will put you in jail. You are not allowed to drive. You do not have a Texas driver license. I am now making that a condition as well. Do not drive. You will be signing a promise with me. This is an affidavit, Ms. Juarez Hernandez, that you're not to drive. I don't care what's going on in your life. Do not drive. There's no quicker way for you to go to jail. You understand? Okay, you want to apply for an appointed lawyer, man. Okay, we'll give you an application for an appointed lawyer. I will have you speak to a lawyer today. First, I will have you come up here, swear to us that you're not going to drive. You'll get to Victoria, sign a reset, and then she will give you an application for an appointed lawyer, and I will take a look at it. How many more Spanish speakers do you have?
3 more.
I'm going to do this one, and then I'm going to stop with Spanish for a while. Are you Mr. Olverio? Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On July 6, 2024, at 8 a.m., officers were dispatched to a suspicious event call.
Did you say 8 a.m.?
Yes, Your Honor. Upon arrival, they observed a vehicle disabled in a moving lane of traffic with the defendant sleeping on the pavement next to the vehicle. The defendant had an odor of alcohol on the breath and bloodshot eyes. He had a calm demeanor and slurred speech. There were 2 beer bottles in the back right passenger floor, one unopened and the other one had approximately 8 ounces remaining. The vehicle was registered to the defendant, and the defendant was ID'd by his California driver's license and El Salvador passport. The defendant admitted to driving the vehicle and stated he was driving home from a friend's house in Rosenberg and had been driving approximately 30 minutes before parking his car, falling asleep. The defendant stated he had 5 beers at his friend's house. Standard field sobriety test was conducted, 6 of 6 on the end, 0 of 8 on 4 of 8 on the walking turn, and 0 of 4 on the one-leg stand. DIC was red, breath was a .138 and a .133. No, Your Honor, just 1 possession out of California with an unknown, just says controlled substance.
I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or prescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of dope, I will put you in jail. You will not get any more PR bonds. You understand? Are you a United States citizen?
No.
Are you a resident? Do you have permission to be here or no permission?
Not yet.
So are you in this country with the?
No, por el momento no tengo. I don't have any.
If you go to jail and immigration finds you, they're going to put a detainer on you. You will be stuck like Chuck in jail for the next 6 to 9 months, waiting for immigration to do whatever they're going to do to you. Behave yourself while you're out in the free world. Otherwise, I will take it away from you. Do not drive. Do you understand? Yes or no?
Yeah.
You will be signing an affidavit with me today, promising me that you're not going to drive unless we know that you have a Texas driver license. You're not allowed to drive. Do you understand, sir?
I understand.
Okay. We're going to reset your case to give you time to hire a lawyer. I'm going to have you come up here, swear to us that you're not going to drive. After that, you'll get to Victoria Room, have you sign a reset. You will meet with Tracy for your bond conditions, and after that, you'll be free to go. Show up.
This is where the story of War Borden begins. And this is the war of ours.
Come back, because if you do not come back, I will issue a warrant. You understand? All we're asking you to do is don't drink, don't use drugs, and do not drive. Understand? Come on. Good morning, Mr. Thompson. Charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
April 15, 2024, complainant defendant Arky, Texas. A complainant confronted defendant about taking her car keys. Defendant immediately shoved a complainant, so complainant said that she was going to call the police to report that, as well as defendant's past violence towards the complainant. Defendant told complainant they'll be sorry for doing that and then left the scene. Complainant told officers that earlier in the day, complainant threw a rock at defendant's vehicle during an argument. Defendant responded by grabbing complainant by the hair, dragging her up the stairs into the home and throwing her to the ground, causing her to feel pain. Complainant stated that she didn't initially report for fear of retaliation and is now requesting a protective order.
The alcohol mentioned? No? Okay. All right, Mr. Thompson, I'm going to find that there's probable cause to go forward with the case. So she does want a current protective order.
We have completed the RIF this morning, Your Honor, and she
Okay.
wants him to come back home.
What do you think? What's your position?
I would like him to be able to come back to the house, but he has no prior assault cases. This is his first domestic violence case. It happened back in April, Judge, 3 months ago, and there hadn't been any issues since then. I'm going to tell him and her to go into some counseling. I think that might be beneficial to the couple. But I do think.
Mr. Thompson, the problem is that I don't know what kind of relationship you have with this person, but if it's a volatile relationship where both of you are constantly at each other's throats, I don't want to talk about the case, right? My only concern is I don't care about past. I care about the future. And if you're someone that loses your temper easily and she knows how to push your buttons, is it a decision to go back? I don't know. I'm going to leave that up to you. I am telling you now that I am going to issue the protective order. The protective order is such that she is now labeled as a protected individual. You cannot commit family violence and assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is a stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. This usually also comes with a residential restriction, meaning that you cannot go back to the house in question. I will take this off if she's okay with you going back, but everything else in the protective order is stuff that you shouldn't do anyways, right? And understand though, can words violate this statute? Can conduct violate this statute? If I go like this, is that threatening or harassing? It most certainly is. So conduct alone in and of itself can violate this protective order. That's why I'm saying, I don't know what kind of relationship you have with her, but if it's a kind where you're constantly butting heads, I would be very careful. She knows how to push her buttons and she knows how to contact the DA. All she has to do is say something. Guess who goes to jail? Be careful. That's all I'm saying. So we'll just do threatening, no harassing contact, no weapons, and that's it.
MOAC will need to be amended.
I will.
Just want to make sure. Okay.
Right. So I'm going to issue the protective order. We will take out the residential restrictions so you can go back. Just be careful. When was that granted?
Yeah.
What's today? Sure. Yeah. You have a lawyer. I will waive your appearance so you don't have to waste your time coming to court. But stay in touch with him and he'll tell you if and when you have to come back. Okay? If he tells me he can't get a hold of you because you're playing games, I will issue a warrant. So just be careful. Stay in contact. That's it. You have any questions? Okay. Thanks.
Thank you. You have one other case, Mr. Stewart.
I know. I'm not ready to do that yet. That's going to
I'll come
take.
back. I've got it.
Please, where's Mr. Stewart?
It should be pretty, it's an address violation, but it happened during the storm and he had no power or AC, so they went to his sister's house. And that's the address on the protective order. I'm not sure why it was a restricted address, other than that's where.
I don't know. Let's Can you go do other stuff? Let me blow through this and yeah, for sure. So let me get this right. You're on a diversion program and you've now picked up a new case. Am I right?
Yes, Your Honor.
What is the one thing we asked you not to do, Mr. Uskanga? Right. And did you do that? We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You're now charged with another misdemeanor, evading arrest. You're facing up to a year in jail and or a $4,000 fine. Please.
On June 30th, 2024, officers were dispatched to a club where a man and woman were denied entry because they were too intoxicated.
A club.
I was going with the group.
Stop. I don't care if you're with the Pope, Mr. Uskanga.
And the man and woman got into an argument. The female fell on the ground multiple times and eventually bit and kicked a police officer. While all this was happening, the defendant kept interacting with her, causing her to be more agitated. Officers asked the defendant multiple times to get back, but he kept encroaching. Due to him being uncooperative, uniformed officers attempted to detain him, and he fled on foot approximately 100 feet before being detained.
He actually came back, was on the court, Judge. They yelled at him and he turned around and came back. That's what he did, run off at first. I'm representing the co-defendant, so kind of.
Who's Carlos Gomez? You're Carlos Gomez. Mr. Gomez, you're charged with racing on the highway. You're facing up to 6 months in jail and or a $2,000 fine. Mr. Kasim, you are charged with racing on the highway and you are charged with unlawful carrying of a weapon. On the weapon case, you're facing up to a year in jail and or a $4,000 fine. On the racing, up to 6 months. As you, Mr. Rios, you're facing up to 6 months in jail and or a $2,000 fine on the racing case. Gentlemen, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay?
On February 1st, 2025, an officer who was part of a plainclothes traffic crimes task force was near Cross Timbers and East Texas Freeway in Harris County, Texas, where there was known to be a large street takeover group meeting. Officers in plainclothes were conducting a surveillance of the group of cars known to conduct the takeovers. The officer followed members of this group, specifically a gray Camaro, a white Camaro, and another Camaro. Officers witnessed the three vehicles slow down to 50 miles per hour and accelerate simultaneously up to speeds well over 125 miles per hour in order to outpace each other. Plainclothes officers were able to keep these vehicles in sight until marked patrol vehicles arrived and conducted traffic stops. Officers pulled over the vehicles and made an arrest.
So each one of them are in cars lined up?
Yes, Judge.
Okay.
Lane 1, lane 2, and lane 3.
Okay, so tell me about the gun on Mr. Kasim's case.
I'm sorry, Judge. What was the question?
So Kasim, it's Kasem. While you're looking at, gentlemen, I'm going to find that there's probable cause to go forward to the case. I'm going to tell you now, living in a city as big as Houston without the ability to drive blows. And I am now ordering you as a condition of your bond not to participate in these types of activities anymore. Racing, street takeovers, donuts, reckless driving. If I find that you do, first thing I'm going to do is I'm going to put you in jail. The next thing I will do is I will take your ability to drive away from you. Do you understand? Not only that, the Texas legislature has made it extremely easy for DAs across the state of Texas to seize, take cars permanently for people who are continuously participate in these activities. And I'm telling you because I've seen it here where people get their $80,000 to $100,000 car seized and taken, and they don't get it back. Do you understand?
Yes, Your Honor.
And Mr. Kasim admitted to having the handgun in his fanny pack to the officer.
So can you file those conditions on all these gentlemen? Or I guess, let's go through each of them. Do they have Texas driver license?
They all have eligible Texas driver's license.
Great. All right. One more thing, gentlemen. You are not allowed to drive unless you have liability insurance in your name. If you do not have car insurance, then you're not allowed to drive. If I find that you drive without car insurance or you violate any of these conditions, I will put you in jail. I will do everything in my power to protect my community. Imagine you hit something at 125 miles an hour. You crush anything. Do you understand?
Yes, Your Honor.
I will have you each take a seat while we craft your bond conditions. We'll have you sign it. Because you guys have lawyers, I will waive your appearances. So you don't have to waste your time coming to court, but you must stay in touch with counsel and they will tell you when you have to come back to court. If they tell me they cannot get a hold of you because you're ducking and dodging and playing games, I will issue a warrant for your arrest. You pick up a new case, I will issue a warrant for your arrest. You become a danger to my community, I will issue a warrant for your arrest. Understand?
Yes, sir.
All right. I'm going to have you each go to Victoria, sign a reset, and then we'll have you take a seat in the jury box.
Gomez?
And then if you can file all those and all of them. Thanks, Brent. All right, so Mr. Edwin, you're charged with evading arrest or detention. And criminal trespass. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 21 days in jail on the evading, credit for 7. Is this what you want to do, sir?
Say that I'm getting out tonight.
Yeah, it's time, sir.
So time served is very sexual to me. Thank you so much for it.
But you need to understand, this is going to go on your record. If you run from the police again, they can charge you with a felony offense. Do you understand?
If our Salveria toll licenses does not want me to get in trouble like this again.
I didn't hear.
Salveria toll licenses does not want me to be acquitted and being in a judge's face like this again.
He's saying somebody doesn't want him to get in trouble again like this.
You know what we're doing today, right?
Today is the lawyer's offense of licensing me to get out of jail, yes, sir.
Well, you're pleading guilty. Is that how you understand it?
Well, I'm not necessarily pleading not guilty, yes, sir.
Are you guilty?
I am fully registered to be guilty.
What happens if you pick up another evading arrest?
You are resourceful enough to not do it. So we don't.
What do you say?
He said we are resourceful to knowing to not do it.
Hey, don't. You can get a felony next time. You understand? All right. You're giving up a lot of rights by doing this today. You don't want a trial. You don't want to talk to witnesses. You need to understand that there are consequences that will go on your record. It will be there forever.
Just be like Salveria toll licenses. I am just be like I am the CEO of Salveria toll licenses, which means I am a lawyer. To understand that.
Let me reset it, Judge.
We do not want to get in trouble.
Let's go back.
We're saying we do not want to get in trouble.
I want to make sure you understand, Mr. Edwin. Mr. Edwin, we just need to make sure you understand what's going on. Okay? You know that you're pleading guilty to this offense.
Yes, sir.
Yes, sir.
Do you know what that means?
Taking convictions.
Right. So you know that this charge will go on your record, correct? If you run from the cops again, you'll be facing a felony charge. You understand that? Okay. You also need to understand that by pleading guilty, you are giving up many rights. You don't want to go to trial. You don't want to talk to witnesses. You don't want to confront, cross-examine the people who are accusing you of this offense. You give up the right to appeal. Once you plead guilty, you can never change this. Do you understand? One more thing is that if you're not a citizen, they can deport you, exclude you from the country, or deny naturalization. Once you plead guilty, you can never change it. Do you understand? Okay, how do you plead to the offense of evading arrest or detention? I will find you guilty. I'm going to follow the agreement.
Okay, I need everyone to rewind that. Did he just say he's the CEO of Solaria to licensors, and that means he's a lawyer?
I don't want you to pick up any new cases.
Yes,
Nice.
I'm continuing to do that today. But interestingly, I guess, though, you're lucky.
Listen, I'm giving you a lawyer. Just stay in contact with him. He's usually pretty good about staying in contact, okay? Don't pick up any new cases. I don't want to have to put you in jail, all right? Just be nice when you're out there. All right, we need him to sign conditions, and then you guys are free to go, okay? All right. Do you mind filing that? There's no contact with the complaining witness and no going back. You're on a deferred, the type of probation for an extremely serious case. I mean, it's about as serious as it comes. You're supposed to live with a halo over your head, you know? Don't say anything. I'm just telling you, you gotta live like you got a halo over your head. You've picked up a new case with us. Lori is asking me to give you a PR bond. And I think everybody deserves a chance. So I will give you a PR bond now, but I'm not going to play this game. If you continue to pick up new cases, if you're a danger to my community, I'm not going to keep doing this. Do you understand? Okay. The problem is that you've not made bond upstairs, so I don't know if you're going to be able to, whether they're going to give you a PR bond or one, I don't know. So I will give you one with us on our failure to ID case here, but be good. It's not hard. Be good. No. Tell Lori, just what you got to worry about is upstairs, not us. Just be good. It's not hard. Do you know when the felony
They
case is?
they haven't put a court date on there.
Actually, they have. 2/12.
Oh, okay,
Next
so
Wednesday.
Wednesday, and I'll reset you until the Tuesday after that.
You want to do the next day, perhaps?
Okay, we can do Thursday.
All right, and we are here now due to Mr. Kabir having a bond violation. This is our third bond violation report that we have had. Our first bond violation, so I guess let me start up. Mr. Kabir is charged with driving while intoxicated. He was ordered as a condition of his bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. State, does he have a DWI open elsewhere to refresh my memory, please? Mr. Salinas, did he not have a DWI?
He currently, yes, Your Honor,
He has an open DWI where?
in Navarro County.
And so we put conditions on him. I can't. Please, Felicia,
The most recent ones, Judge, or there's been a few that we've amended over time.
what are the current conditions now?
The current conditions now are a hearing report every time the case is set on docket, no new law violations. Install a IID device in the vehicle, no driving without permission of the court, no drugs, no alcohol. Plan to obtain a scram device, and to submit to drug and alcohol testing at the court's discretion.
Did he have a curfew as well?
No, Judge.
He originally had a curfew, Your Honor, but because there were no issues with that, we had it removed.
Okay.
Yes.
And so now our first bond violation report that we had was September 23rd, 2024. And in that one, he had been in lockout for failure, I guess, to pay. I don't know, which is weird because we normally always pay for all of them. A second bond violation report was filed January 6th, 2025. Where I guess he was in lockout again because due to no recalibration of the device. And we now, February 4th, 2025, have a third bond violation. And in this violation, the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device has reported one consumption event that occurred on January 16th of 2025 at 11:55 p.m. It was also confirmed by a scram analyst as well. Correct?
Yes, Judge.
Okay, so.
Yes, Your Honor. So, yes. So to begin with the first amended order for pretrial, so if the state wants a copy, I have a copy to show them, but sure. So, Your Honor, just going to the very first order, as Your Honor just noted, usually agency fees are waived for that. However, the box on that for saying that the fees were waived, I believe, were not checked on that. Further, Your Honor, the main purpose here for your determination of giving someone bond in the first place is to establish that they come back to court. So are they a flight risk? And then also, are they a danger to the community? Now, Your Honor, if an interlock device is in lockout on a vehicle, it doesn't start. No one's driving that vehicle specifically. There's no way that they can. I could call a witness to testify that, but I know that you
But that doesn't
are aware of
excuse you
that.
from violating the conditions.
Your Honor,
Are you justifying that because of that you can just?
No, Your Honor, I'm trying to contextualize this because we've been here 2 prior settings before. I know you've concerned greatly about the number that it's at number 3 now. I'm trying to establish that the first and second, there was no indication of alcohol consumption or drug use during that time.
It wasn't working. How are we supposed to know?
And Your Honor, again, one of the two main points of determining what kind of bond, both the conditions and amount are, will they return to court and community safety? Here, my client who's being, accused of DWI, wasn't driving that vehicle. So it was impossible for him to be driving that vehicle, Your Honor. So I ask you to take that into account as far as public safety goes. As far as this latest bond violation, it's the state's burden to prove that my client violated his bond. All we have right now is a report by Scram, but no one is here to testify on behalf of. Well, we can call that, Your Honor, but sure.
Judge, I spoke with the defense counsel today, and he said that he was not requesting to have anybody come here to testify to the Scram device.
We have Felicia that can be called up as a witness to testify as to what happened with and whether he tested positive or not, whether he's consuming alcohol.
It's also the state's burden to prove that he did that. So that's, yeah.
Please.
Yes, Your Honor, we would call retrial services, Ms. Felicia Charles.
Okay, ma'am, would you please come up, raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
So you have first amended order and then second, third amended retrial supervisions and then the fourth. So referencing the fourth amended order for pretrial supervision and bond conditions, I need you to recognize this. Yes. Can you tell us what this is and what are the conditions that are checked? These are.
Sorry, could you repeat what you just said?
Sorry, I said I don't know if she needs that. It was an extra paper.
Okay, I just want it on the record.
Sorry.
That's all right.
Yes, these are pretrial bond conditions, and these are listed as appear in court every time the case is set on docket unless the judge waives appearance. No new law violations, install ignition interlock within the vehicle, no driving without permission of the court, no drugs, no alcohol, and then to obtain, we do have a curfew of 9 p.m. to 6 a.m. and then a Scram device to be installed. And so what we're showing you is what's been marked as State's Exhibit 1, and we'll tender this to defense for any objections.
No objections.
Admitted as one.
So in this case regarding the Scram device, can you tell us about that? Yes, so what exactly about? What is that? What's the standard procedure someone's supposed to do? Yeah, so a Scram device is ordered and it tracks the press.
Objection, Your Honor. The foundation, I believe the state is trying to ask her to testify as far as are you trying to establish her as like an expert on Scram?
And I was not trying to establish her as an expert, just from her experience, what the Scram device is basically for, which she can testify to as a trial.
I'd ask that the court consider that as that testimony as a layperson, not as for the purposes of establishing expertise.
So I want to know whether there's a violation for alcohol consumption.
Yeah.
So, what day do we have any kind of hot blows? What's the amount? Do you have anything of that nature?
Yes, so the report should have been provided to the bond violation email as well of the graph. And I'm showing her now what's marked as state's exclusive. For the exact amounts and everything, I would need to look at the report that was provided in the email.
Okay, please.
Have the graphs been printed, state, or she's just referring? Yeah, just so we can all agree on what she's referring to.
And I'm showing you what we marked as state's exhibit 6. Can you please tell us what this is? So this is a Scram report sent back to us whenever the device information and data is pulled. And this is what the analysts observe for either tampers or consumption. And this is what they send us back if there is a confirmed tamper or consumption as per.
Okay, so this fairly accurately depicts and scram for and that it says it is.
Yes,
We will tender the defense for any objections and note that this has been, is it correct to say this has been emailed to defense prior to this date?
yes.
Defense received it, no objection, Your Honor.
Okay, it'll be admitted.
Okay, so can you tell us about the specific dates in this report again that was given to defense prior to today of the basic dates that the scram was not completed properly?
Yes, so the device seems to be fully functioning. And on January 17th, Friday, January 17th, the scram device picked up a peak TAC of 0.078%. And then established a zero baseline once again for the dissipation rates of the alcohol at 9:05 a.m. on January 17th.
Say it again.
9:05 a.m. January 17th, 0% TAC was reestablished for the dissipation of alcohol.
Okay, and for those dates, the ones that match on what I'm showing you as State's Exhibit 2, the bond violation report, can you please, do you recognize this?
Yes.
Can you please read the details of the violations here?
Yes, it says the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device has reported one consumption event. The confirmed alcohol consumption occurred on January 16, 2025 at 11:55 p.m. This information was received on 1/17/2025 and confirmed by a scram analyst.
Thank you. We pass the witness.
Okay.
All right. Good morning. I just want to, if you could turn to, I believe it was the State's Exhibit 3, I think, for the scram non-compliance report, the cover page. Do you see that? Yeah, what she has right there. Oh, is it 6? Okay. Would you stay, since you're close, would you give that to her? Thank you. So just looking at the cover page there, can you read who the agent is on this report?
Justice Turner.
Are you Justice Turner?
Yeah.
Have you consulted with Ms. Turner about this report?
Through the emails, yes, for the bond violation report and the.
What exactly did those conversations include?
The entire.
So let me, sorry, that was a poorly phrased question.
I'm sorry,
No,
I don't understand.
that's my fault. Don't worry about it. My question is, did she consult with you when compiling this report?
Would you be more specific?
Did you help in the assembly of this report?
No.
Okay. Have you ever assisted or aided in the assembly of a SCRAM systems non-compliance report?
No, no one.
No, no one in the department does. Okay. And do you have any sort of, have you ever worked for SCRAM systems?
No.
Have you ever had any special training in SCRAM systems?
Yes.
What is that training?
I actually met with Ronald Grant from Sentinel, the regional representative, about maybe 2 months ago to get an advanced knowledge of this device. This is one of the very few devices that I do have advanced knowledge in, but not expertise.
Sure. And what exactly did this person teach you?
We
Briefly.
learned how to read the graph, kind of how to establish consumption versus a tamper, environmental factors versus consumption, et cetera.
Okay. So during that training, did you ever actually look at a physical device, the SCRAM device?
No.
So you didn't do any live experiments where, for instance, you put on a SCRAM and then, drank alcohol to see how that works?
No.
No. Okay. And as far as Mr. Kabir's SCRAM device, have you examined it prior to this hearing?
Me personally, no.
Okay. And so one second. So is it fair to say that you've been thoroughly trained on the theory of scram device and alcohol detection. Is that fair to say? That let me rephrase that. So you don't have any actual technical experience with how the scram device detects alcohol in someone's skin. Is that fair to say?
Thank you.
I don't want you to think. Is it yes or no?
I still don't understand.
I'm trying to understand too.
Do I not understand how a scram device works, or have I not for myself? And
Sure. So, this is pretty, is it fair to say like the science is kind of advanced here? Like when you received your training, did you have the personal opinion that that was advanced science that you were learning about?
I believe so.
Okay. And you don't, so basically it sounds like your training, and correct me if I'm wrong here, your training was mostly so you could be able to make sense of what a report says and not necessarily how the actual device itself works. Is that fair to say?
Partially, yes.
Okay. What's what am I partially wrong about?
Yes, reading the graphs, but then also what kind of would entail, what would mess with the device.
Okay.
Essentially, as well with tampers, environmental factors with that, makeup or placing something between the skin, how things are worked around with the device, how people evade from, having the correct reading on the device.
Sure. And so that's, you basically learned that all in theory, right? There were no withdraw that question. So I'm just saying there was no actual, you didn't look at any studies. Did you read any studies when you did this? Okay.
I actually met with him due to another case. I wanted to further understand it, so we examined the report for that.
Well,
and also reviewed some of the peer reviewed articles.
Well, that's great. I'm glad that you want to, a lot of people won't, they'll just kind of do their jobs, right? I'm glad that you want to further knowledge, but what I'm trying to get at is it's fair to say that knowing how something works in theory and actually examining the actual thing itself, the practicality of it is different, right? You agree with that statement?
Yes.
Okay, so without actually having examined in your own personal observation, how a scram device detects alcohol in someone's system, it seems that, is this fair to say that you're very, very well versed on theory, which is probably more than some other people, but not necessarily on the practicality of detection?
Question asked and answered.
Okay, just, let's go.
All right. Just ask the question. I don't know if that was an objection or sustained or overruled.
Let's just move on. I mean, we're here to see, is there a positive blow or not? She's testifying that there was.
Sure. I'm just saying that this, all right, I'll make my argument in closing. I don't have any further questions. Thank you.
Okay, closing, or wait, hold on. Anything further from the witness?
Two very quick questions, Your Honor. So do you get notifications if the scram device has been tampered with?
Yes, we get notified of tampers and consumption events.
And you get notifications if it's been cut off? Like, just what's been going on with the scram device? You get those notifications?
Yes.
Okay, thank you. No further questions.
Matt?
No further questions, Your Honor.
Okay, thank you so much. Okay, argument.
So, Your Honor, this is a pretty basic, simple case. The bond violation report is evidence the defendant was ordered to obtain a scram device and for refraining from alcohol consumption and not tampering with the device. The defendant's scram device was reported on one consumption event. This happened January 16th of this year at 11:55 p.m. and this information was received on January 17th of this year at 5:18 a.m. And clearly, there were up to 4 amended orders for pretrial supervision and bond conditions. It was obviously which the defendant was supposed to do, and he directly violated the order, was evident by the pretrial services and bond violation report. So it's pretty clear here that we would be asking to revoke bonds in this case.
And we would just like to urge that this is a clear and convincing standard, as I already know, Judge, it's not beyond a reasonable doubt. I don't think that we need a scientist here to prove that the scram device is a device that can be detected.
Okay.
Yeah, Your Honor, I agree with state insofar as this is a simple matter. Where we disagree is, I think a scientist was needed. I think someone who actually has the technical know-how of how this violation report came to be. The state did have that standard of clear and convincing to prove that my client violated this. So far, all we have is a piece of paper that is, at least for right now, is supposed to have been prepared by someone else who is not here to testify. There's no ability to cross-examine them on their expertise, on any notions of false positives, on any issues that a technical expert would actually know about the device. And without that, Your Honor, I think it's very clear that the state failed to prove their burden of proof that my client consumed alcohol. And I would ask that, Your Honor, again, not revoke the bond, keep it as is. My client's here. There hasn't been any warrants for his arrest issued since he's been coming to this court. And in the allegations itself of the underlying offense, there is no allegations of injuries or accident to persons. So again, just taking into account that you need to take into consideration flight risk and safety of the community. Nothing that's been established here in this hearing or outside of this hearing should lead the court to believe that my client is a flight risk or a danger to the community. And with that, I'd ask that you not revoke the bond, Your Honor.
And Judge, these devices are used. Say it again. These devices are used all the time.
Well, their use all the time is
Just so-
irrelevant to needing an expert to testify on that.
Absolutely. I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. It would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking your bond. He goes with you.
We have the positive THC or stuff.
He had a positive THC, right?
Yeah,
As well.
that we sent him earlier this week.
He also tested positive for
THC.
marijuana as well.
Well, Your Honor,
Yeah, this week.
that wasn't, are we still on the record then on that? Okay. Well, I would also want someone to come testify about that, Your Honor, but you know, that I'll make, I know, but I know you already made your ruling, but I was ready to testify on that because they don't have anything on chain of custody on the test itself, on whether it tests cannabinoids, which Delta-8, hemp. There are a bunch of things that are THC related that could pop positive for THC that aren't THC.
Regardless, we admonish him not to put anything in his body that doesn't have any Delta whatever. Regardless, it's number 3, goes with you. Off the record. Sorry. Thank you, but I just can't.
Well, I'm going to take a break for a second.
With an open DWI and a third, that's it. I can't just keep doing it. You know, at some point, I become an enabler.
Boom. The hammer finally drops. This is a massive moment.
Facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Sir.
On January 31st, 2025, it says the officer observed a Dodge Challenger run the red light in an attempt to make a U-turn in a sudden acceleration and almost strike a vehicle that was traveling north and had a green light. The vehicle had to perform an emergency maneuver to avoid the Dodge, but did not stop and continue northbound on Westlake Houston Parkway. The officer initiated a traffic stop. And the defendant was pulled over for reckless driving and running the red light.
So you said he's at a stoplight?
Yes, so he ran the red light in an attempt to make a U-turn while somebody else had a green light and almost struck the other vehicle. And he
Okay.
also had 0.20 grams of Tylenol. On him. That's what the DIN says.
So I'm going to find probable cause now. Do your diligence, get the video. If you show something different, come back, let me know. We can always revisit probable cause at a later time. Okay? Do you see whether he has a Texas driver license, please? Mhm. Mr. Gutierrez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to drive in a reckless manner, no racing, street takeovers, donuts, anything of this manner. If I find that you do, or you put my public in danger, I'm going to revoke your bond, put you in jail. So you understand? Yes, sir, I do.
Eligible driver.
Okay. Now, he's on felony probation upstairs. Are you familiar with this?
Not with the felony probation judge. Have they, does it show they filed
He's,
MAJ yet?
I don't know. Let's look. You're on probation. It looks like it may be a second or first degree felon. Yeah, second degree felon. Let me see. So just be on the lookout. You know, it's very well they may file a felony warrant now. He's already had one MAJ dismissal. So be on the lookout, sir. Sir. So do you mind filing those conditions, please? All right. You're also, Mr. Gutierrez, not allowed to drive unless you have valid liability insurance in your name. If I find that you drive and you don't have car insurance, likewise, you'll end up going to jail. You understand? Now you have a lawyer. Because you have a lawyer, I'm going to waive your appearance, but it is your responsibility to stay in touch with Mr. Henderson, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for arrest. For now, I'll have you sign a wreath of victory. We'll have you take a sit in jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Thanks, guys.
Now, just you?
Got it.
All right. You can adjourn.
Good morning, Mr. Concepcion. So you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. Is it on docket today or no?
Not on docket.
Okay, that's what I was, okay. So it's a straight probation as well.
It is, Your Honor. I asked for deferred, but we settled on straight. He's on deferred on a felony.
Perhaps that's why. All right, let me see.
He did miss court a few weeks ago, Your Honor, so there was a warrant.
Is there a felony warrant right now?
No, there should not.
Sure.
They reinstated like his probation on the 9th of January.
And he has been meeting with his probation officer.
You need to understand something, that you're on probation for an extremely serious case. You're looking, I don't even, is it a first or second degree?
Second degree. I think it's second.
Second degree prosecution.
You need to understand, these types of probations, when you get revoked on a second degree, you're usually looking at double digits, probably 10 to 12 years in prison. You have any clue what they would do to you in prison? No, you don't. Have you been to prison before?
Sir.
Your potential, how many times have you been to prison? Once, twice? You could be a potential 15 to life case from now on, man. You know, really. Not only that, it's a 3G. You get revoked, you're doing half the time before you're even eligible. There's only so many times that they're going to reinstate before they start throwing the book at you. You know what I mean? Really.
Yeah.
So you've worked out an agreement where they're offering you 1 year in Harris County Jail to be probated for 6 months. As part of the agreement, the only thing that you have to do is stay clean. Literally, it's the only thing you got to do. Can you do it?
Yeah.
If you don't, I'm going to put you in rehab myself. You know, really. Not only that, but depending on what you're taking, you take too much of it, all you're going to do is put your lungs to sleep and you end up dying. We see it happen here all the time.
Sure.
You built up that tolerance, you keep taking it, and then, you know, you're chasing it, right? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this, there's no changing. You understand?
Yes, sir.
This is what you want to do. You know, I got a figure of all your criminal history here. I wonder how much of it is related to, you know? You're young. Get off. Do something else.
I just turned 30 years old.
Really? And this?
Yeah.
All right. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I'm going to send you to the agreement. If you want any help, come back and we can help you out. All you got to do is ask. But if you go out there, if you take off, you pick up a new case, you test positive, I'm going to put you in jail. I'm going to issue a warrant for arrest. We're going to bring you back. We're going to have a hearing. And if they prove it to me, you're looking at a year in jail. Do you understand?
Sure.
All right, man. Good luck.
Thank you, Your Honor.
Got it. Are you Miss Somali Lerner?
Yes.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Judge, on January 30th, 2025, officer ran a check on a vehicle in Harris County, Texas without proof of financial responsibility. The vehicle also had a defective brake lamp. The traffic stop was initiated. Defendant driver ID'd by Texas driver's license stated she did not have insurance for the vehicle. Officer observed defendant to have thick
Bloodshot eyes or thick slurred speech.
Speech and the odor of marijuana emitting from inside the vehicle.
Officer asked defendant when she last smoked inside the vehicle. Defendant stated she had a few roaches inside the vehicle. Probable cause search was conducted. Officer found 0.103 ounces of marijuana. A DRE officer arrived on scene and conducted Romberg test. Defendant estimated passing of 30 seconds and 12 seconds. Shows D is in an elevated state. DRE also observed thick SS, FSTS conducted 6.6 HGN, 3 out of 8 on walk and turn, 2 out of 4 on one-legged stand. When defendant was arrested, D repeated the phrase, "Oh my God," several hundred times. Officer knows from ARIDE training that this is a symptom of dissociative anesthetic. The SC read, D refused to sample the breath, blood. Search warrant signed and executed.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Can you look to see if she has any prior DWIs? Number one. Number two, if she has a valid Texas driver license, please.
No prior DWIs.
Okay,
And your driver's license.
great. Okay. Ms. Lerner, like I said, no alcohol, no drugs. I'm going to randomly test you. Do you have the ability to hire a lawyer or would you like a court-appointed lawyer? Okay, I need you to fill out an application for me. I'll take a look at it. And then for now, I'll also have you sign a receipt with Victoria. I'll later have you get with Fleischier for your bond conditions and then I'll have you meet with a lawyer.
Her license being suspended.
I'll let you talk to a lawyer about it. I can't give you legal advice. No, assuming we give you a lawyer, you can ask the lawyer and the lawyer can advise you properly.
I need to start working. I lost my job.
Just, yeah, talk to the lawyer and they'll be able to advise you properly. I haven't, as long as you have a valid Texas driver license and you have liability insurance, I'm not taking away your privilege to drive. Okay? So, yeah. All right, let me have you get with everybody and then we'll have you speak to someone here momentarily, okay? Please. Matthew Leonard.
Yes, sir.
So Leonard, you're charged with driving while intoxicated, second offense. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, on 4/12/2023, officers were dispatched.
Hey, yo, hey.
Another story about that, right? On 4/12/2023, officers were dispatched to a crash involving a bus and a car at the 1700 block of Travis Street. Officers made contact with the defendant who was slumped over in the driver's seat of the car. Officers observed the defendant to have red and glassy eyes, strong odor of alcohol in the breath, SS, and slurred speech and incoherent speech. Defendant told officers that he was drinking 211's beer at his house and last drank 2 hours ago. Defendant was taken to the hospital and diagnosed with a minor brain injury. Officers got a blood warrant. There was a blood draw completed at JPC.
Then, so what, do you have the results? Hold on a second, let me see.
No, not yet.
No, Judge, we don't have any blood results
I see
yet.
it.
For some reason, there haven't been any to-dos done on the case. I'll submit them immediately. That's.
Well, it looks like it's because it was a 2B, that's why. So it's from April of 2023. Looks like there was a blood of a 0.198. Okay, Mr. Leonard, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. Because it's a second offense, I'm now ordering you as a condition of your bond not to drive any vehicle that doesn't have an ignition interlock on it.
Yes, sir.
Please, can you run his license, see if he has a valid Texas driver license, please? Do you have the ability to hire a lawyer, sir?
How much time can I pass this? Because I'm in the process of getting my ID and everything, because when I got locked up, I didn't have my wallet. They threw it away or something.
Would you like a lawyer, sir? I can give you a lawyer today. Okay? So understand something, Mr. Leonard. I don't want you drinking. I don't want you using illegal drugs. I'm going to randomly test you. And you're going to have, do you show a Texas driver license?
It's all in.
Okay. All right, sir. So what I'm going to have you do now is I'm going to have you sign a bunch of paperwork with Victoria, Felicia, and then I'll have you meet with the lawyer here momentarily. Okay?
Yes, sir.
Please. All right. Good morning, Mr. Hunter. We're bringing you back because you now have a new fugitive case and you have a new lawyer. What would you like?
No, we're seeking fugitive bonds on these matters. The new matter, to the best of my knowledge, this from North Carolina, is basically the same complainants of the Houston case. Same folks. I think their surname is Beaker. I think a $30,000 bond has been set in the case here in Harris County. We would respectfully request bonds in the amount of $20,000 on the 3 fugitive warrants. And let my client sort things out with those other jurisdictions as well as ours.
Your Honor, because of the fact that he has now 3 fugitive cases in our court, 2 out of Knox County, Tennessee, and now a new one out of North Carolina County, we'd be asking for no bond.
I told him beforehand, we've visited this issue before, and I told him the last time that he was here that I wasn't going to give him one. He just got way too much baggage. And it's all the same thing where it's a theft from an elderly, and we have the same thing that's occurring over and over and over. You know, and it scares me that if we let him out, is he going to pick up a 5th case, you know? Or it just, it's so much baggage. He scares me, you know? And
he does have, he's kind of been a resident of this area, you know, for 25 years. So
I get it, but he's got a lot. He's hopscotching with the states as far as criminality, right? He's got 2 cases in North Carolina, or 2 in Tennessee, 1 in North Carolina. Now he has 1 here. He's got, in 3 different states, he's got charges. It's too much. And I think that because of that, he's a big flight risk, and I don't want to lose him. You know, and he knows this because I've told him this before. You're not the first person that has approached on me with this. You know? So yeah, it's just, you got to understand that there's a lot that comes with this, right? If it was 1, perhaps, right? But you've got 3 in 3 different states. It's way too much. You know, at some point, it's got to stop. Now's that time. So the idea is that has he made bond? He hasn't made bond on the cases upstairs, right? So because you have not made bond, the 14 days here that would normally kick in is told if and until that hold upstairs is released. So if you're able to make bond on that theft case upstairs, that would kick in the 14 days for those states to come get you. And then they would have to battle it out as to who comes and whatnot, and, you know? So I guess just let me know what you guys want to do. The felony court is set for March 11th. Typically what we do is we just set it the day after. And I'm sorry, Mr. You know, it's just too much. Yeah.
Your Honor, I do also want to add, he hasn't waived on this new North Carolina case, so he wants to start that clock today.
And I'll let you guys see if that's something that you want to do. You know, if not, we can go ahead and get a governor's warrant. That'll take 90 days. But, you know, if you post bond on the case upstairs, that would get the ball rolling really, really quick. So, okay. You guys let me know what you'd like to do. Thanks. Hi. Hey. Happy Friday, man.
Happy Friday. We are here.
Who do we have here?
We have Herman Riley, Judge, R-I-L-E-Y.
Good morning, Mr. Riley.
Requesting bond.
Okay, Mr. Riley, I've never met you before. I don't know you. I got to get to know you in the short time that we have here to see who are you? Are you a danger to our community? Well, everybody tells me that, right? Hold on. I know that you have a statement that you want to say, but what really matters is the paper, because that really tells me who you are. I get people that try to sell me the sun, moon, stars, everything here, but that really tells me who you are. So, Dave, let's get to know Mr. Riley.
Your Honor, he's wanted out of Louisiana for domestic battery involving child endangerment and theft, but the theft is a misdemeanor, so he's only being extradited on the domestic. It was where he is alleged to have bitten his live-in girlfriend in front of a shared child and a second child, a 4-year-old and a 7-year-old. The warrant was issued on May of last year, so we're getting close to a year, Judge, for the.
So he's been on the lam, you're saying, for a year?
Well, I don't believe it's an FTA. I believe it's a 2B warrant.
It's a 2B? Okay.
I don't show any other history, and so state just requests that a sufficient bail be set, but I don't know of his ability to.
So you're okay with the bond?
I'm okay with a bond. I'm not okay with a low bond.
Judge, my client has requested that he address the court.
Yeah, I know. So let's not talk about the case, because you have the right to remain silent. Anything you say can and will be used against you. You got to understand that I have a ton of prosecutors here. Whatever you say, they're going to sit there, type it down. It's very possible it may get back to the prosecutors in Louisiana somehow. So don't talk about the case.
Myself.
My only concern is, you know, if I set you a bond, number one, are you going to be a danger to our community? Number two, are you going to go back to Louisiana? Those are the main and primary concerns.
That's what I want to assure you of. Okay, right now I'm working. You know, if I stay here 14 days, I may lose my job. I pay on child support and everything. I talked to the bondsman in New Orleans already. You know what I'm saying? So as soon as I go up there, he gonna walk me out. You know what I'm saying? I'm gonna take care of the bonding and everything. But I just want to let you.
It's set there.
I'm checking that right now, Judge. No, there's no bond set, which means they'll set one as he self-surrenders, but I don't know what they would set it at.
So typically the way it works is if we set you a bond, give you 14 days from the date of your release to go turn yourself into Louisiana. If you fail to go do that, You have to understand that there are serious consequences. I will revoke the bond, set it at 0, and I'm not going to give you another one. I don't care if you're kicking and screaming and Jesus told you to do something. I don't care. We give you one shot to go turn yourself into Louisiana. You understand?
Yes, sir.
Okay, so let's talk about a bond amount.
Your Honor, due to the offense and the fact that 2 minor children were present and the age of the warrant, is that state requests a bond of $7,500.
Well, Judge, we'd request a bond set of 1,000.
Big difference.
It's pretty big divide, Judge.
So the problem is also is that because you're a fugitive, right? You're an inherent flight risk. So the normal 10% that one would have to pay to typically bond out usually does not apply in fugitive cases, as far as I've been told. So you will probably have to pony up 100% of the money to be able to bond out on a fugitive case. So I guess speak with him, let me know, what's something that you guys.
He told me he could make $1,000 bond.
Yeah, I think 1,000 is too low.
That's the amount that he can make.
It's too low. I mean, that's what we do on normal cases, not just,
Unless I get you information, Your Honor, just again, due to the age of the warrant and the fact that there were minors present, unless I get you information.
I don't want to keep you, right? But I have to make the bond sufficiently high so that I know that you're going to go back, right? What I'll do is I'll set your bond at $2,500, okay? And then just let me know, what we can do is, has he already waived or no?
No, he has not.
Have Abel reach out to your folks, your family, to see that's something that whether you guys can make it. And
Under 2,500.
this is not I'm not going to negotiate with you, dude. It's just that 1,000 on a fugitive case with this type is just too low.
And also, just reminding the counsel and the court is that even presuming that he's able to make this because Louisiana has set at no bond for him to return and go back to work, he has to make a secondary bond there. And if this is the maximum he is able to pay, then effectively he'll be held in Louisiana and he won't be able to return.
I'll also have to take that into consideration.
Judge, my client has chosen to not take the bond until if that's okay with court.
2,500, like.
Don't argue with it.
No, I'm not arguing. I just want.
Here, look, let's do this.
I want to lose my job and everything.
Let's do this. I'll let you guys go back there, talk about what you can make. 1,000 is just too low, but I'm willing to work with you because, really. But you guys, no, let's not do it here. Go back there, talk,
I'll stand down, Judge.
Christine?
Thank you, Judge.
Thank you, Dave. So Mr. Schreiber's on bond for a harassment case. He's now picked up a new case.
Yes, sir.
You now stand charged with the offense of assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On January 31st, 2025 in Harris County, Texas, officers responded to a family disturbance call. Upon arrival, officer met with the complaining witness, who stated that she and the defendant are married. Complaining witness stated that the defendant had arrived home drunk and that she hid alcohol from him, leading to an argument. The complaining witness stated that the defendant then grabbed her by her hair and pulled, causing pain.
Is this the same complaining witness in the harassment case?
No, Judge, this is going to be the defendant's wife. I've since spoken to her today in back in the witness room.
Who is the complaining
So
witness?
my understanding is that in the harassment, it's a neighbor, and then we now have the wife as the complainant.
Judge, if I may, then you may remember the old case. It involved a family that lived about 0.8 of a mile away and involved a dirt
I
bike.
don't remember anything.
And as a practical matter, no, it isn't a neighbor. It's a person who lives in the area. They don't, live next to each other. After this incident happened with the harassment case and his wife is here in court, Mr. Schreiber's now enrolled to go to a facility called Mallard Lake. It's a rehabilitation facility that addresses alcohol problems. He's going to be enrolling on Sunday. And they've sent the enrollment paperwork to my office yesterday. We are hoping that we can reset these cases to allow him to attend that. That is an inpatient program. We don't know how long he will be there, but I would anticipate it's going to be not less than 14 days. But of course, it's one of those things they'll judge his success as he goes.
I am all for it. But you picked up a new case while you're on bond. I'm not going to let you go. I'm not going to give you any preferential treatment. You have to abide by all the rules, regulations as well. And when you pick up a new case, there are consequences. You're old enough to know that. You know, when you have actions, you take the wrong action. There are no mistakes in life. There are actions. And when you take the wrong actions, there's serious consequences. I'm now revoking your bond on the harassment case. You're staying with me. You know, now, hold on. I'm not done with you. I'm also ordering you now not to consume alcohol, illegal drugs, and I'm going to put a monitor on your ankle so I know that you're not consuming.
So I still go to rehab?
We'll talk about that.
We'll work through all the, I guess, all the issues as far as there, but I'm not going to take your word for it that you're not going to consume. I need more concrete evidence, and the way that I do that are with these devices, you know, and you're now with me, absolutely no tolerance. If I find that you're now a further danger to my community, I'm going to go nuts on your bond. Do you understand? So what does wife want? Does she want to continue to have contact with him?
She is here to ask that the court modify the conditions of the magistrate order for emergency protection. Since this incident happened, Mr. Shriver's been living in a hotel. They've abided strictly, even with their communication and transportation today, with the no contact. However, she is asking that we remove that restriction and instead go with the no threatening or harassing communication.
I've spoken with her and confirmed all councils represented, and you know, we're not going to be unopposed. We're not going to be opposed to modifying it to no threatening or harassing.
So you have an order for protection that's been put in place by the magistrate. I'm leaving everything in that order intact except for one thing. Well, I guess two. Does the MOAP also say no contact as well?
It says no contact and don't go to their.
Got it. Okay, so I'm going to modify two things. The first thing I'm going to do is I will take off the residential restriction. Number two, I'm ordering you not to have any threatening or harassing contact with the complaining witness in this case. You need to understand what is threatening or harassing doesn't matter what you think. I could give a rat's behind what you think. It's what she perceives.
Man, that might be the most real, off-the-cuff life advice you'll ever hear in a courtroom. So many people that
with it, if they're not okay with it. If they're not, then we can work something out. But the minute he gets out, the next day he's got to get the monitor on if they have a problem with it. And then you must charge this device every single day. If the battery goes dead, so does your bond. Do you understand? All right, so I'll set the new bond at 5,001 on the harassment case, and then we're done. All right, goes with you. Okay, Mr. Downey, so just
We'll get a reset, maybe 45 days out, should give us enough time.
do that. I need proof though. Like, get me proof that he's actually enrolled and how long he's going to be there. On the harassment case, he's going to make bond. They'll give you a 7-day setting on that afterwards. Feel free to get with Victoria so that way you can match up the date after you get the new date, and then
I have the paperwork. How do you want me to get that to the court on the?
if you want to email it to us, it's okay. Email.
Okay.
It's probably the easiest. That way you don't have to come in and waste time.
No problem. Yeah, I will get it to you right now.
And then just one more thing, always just CC Sebastian. That way they always have it as well.
Okay. No problem.
Okay. All right, guys. Mr. Castillo, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 31st, 2025, an officer was working an extra job at Home Depot and was alerted by the loss prevention officer that the defendant had entered the store, putting multiple power tools in a basket, and exited the store with unpaid merchandise inside the basket. The officer was sitting in a motor vehicle and observed the defendant exit the store beyond all points of sale and head north in the parking lot. The defendant entered apartments across the street. The officer observed the defendant pushing baskets and approached the defendant. The defendant attempted to flee. The officer deployed a taser and placed the defendant in custody. The total value of items stolen was $519.98.
Got it. All right, Mr. Castillo, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now not to go back to any Home Depot. Do you understand? If I find that you do, I'm going to revoke your bond, put you in jail. No more PR bonds for you. Do you mind filing that, please? Okay. Tell me, do you have the ability to hire a lawyer, sir?
Yes, sir.
You don't want to apply for a court-appointed? I don't want to talk about the case. Do you want a court-appointed lawyer?
I mean, I could get one, but if I hire a lawyer, then I don't need the lawyer you're gonna give me.
Sorry?
I'm gonna go ahead and get a lawyer for myself.
You don't want a court-appointed lawyer?
No, sir.
Okay. If you have a problem and you're not able to, just come back, let us know, and then we can appoint your lawyer. I'm going to have you sign a receipt of Victoria. I'll have you take a seat in the jury box. Let me get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go.
Thank you, sir.
Don't pick up any new cases. Behave yourself.
Yes, sir.
Do you understand?
Yes, sir.
Okay, man, come on. Ms. Gray, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On January 31st, 2025, at approximately 1:34 a.m., officer observed a vehicle fail to signal a lane change in Harris County, Texas. The vehicle also had unconfirmed insurance. The defendant was later ID'd by Texas driver's license, and upon contact, the officer observed slurred speech, red bloodshot eyes, and a strong odor of alcohol emitting from the defendant's breath and person. The defendant admitted to consuming 3 beers. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 6 out of 8 clues were observed on the walk-in turn. 3 out of 4 clues were observed on the one-leg stand. The DIC was read to the defendant, and the defendant refused a breath sample. A blood search warrant was signed and executed.
What did you say the stop was? I missed it.
The stop was for a failure to signal lane change, and then the officer ran the plate and saw that the vehicle had unconfirmed insurance.
Okay. Ms. Gray, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail.
Judge, would you consider an NOR for this case?
I am, because she just had one that was dismissed. So I am now placing a restriction on your license. You're not allowed to drive any vehicle that doesn't have a guardian interlock on it. If you're caught driving a vehicle that doesn't have one, I'm going to put you in jail. Do you understand? Okay. Now, you have a great lawyer listed in Mr. Darvish, and he'll tell you when you have to come back to court because you have a lawyer. I will waive your appearance, but it is your responsibility to stay in touch with him. Do not pick up any new cases. Don't drink. And if you lose your license between now and then, you're not allowed to drive. Do you understand? I do. Right. The other thing is also a condition of your bond is you're not allowed to drive unless you have liability insurance in your name. Do you understand? So if you drove here today and you don't have liability insurance, you can't drive. You understand? I do. All right. So I'm going to have you sign a receipt. Victoria, we'll have you get Fleischier for your bond conditions, and then you guys are free to go. All right. Thanks, guys. Good morning, Ms. Moya. Oh. Do you speak English or do you need?
I speak only English. Yes, only English.
You speak English?
Yeah, only, yes.
And you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On January 29th, 2025, an officer was dispatched to a Valero parking lot for a suspicious motor vehicle that may have been stolen. Loss prevention on the motor vehicle came back to the license plate, on the motor vehicle came back to a white Ford F-150. The vehicle identification number on the vehicle was different than what had returned. The defendant got out of the suspected motor vehicle, and the officer was performing a felony stop on the possible stolen vehicle with multiple items in her hand. And the defendant refused to obey commands when told to drop them. The officer stated that he told the defendant to face away from him and walk backwards with her hands up. The defendant refused to obey commands and walked towards the officer with her hands down and facing him. The defendant kept moving back towards the front of The defendant kept moving hands back towards the front of her body while the officer attempted to put on handcuffs on the defendant. The officer ordered the defendant to walk towards the patrol vehicle, to which the defendant refused and had to be escorted by force. The defendant kept moving her hands away from the officer, and as he attempted to handcuff her again, the officer had to take the defendant to the ground due to the defendant attempting to free herself. The defendant continued to move around so she could not be handcuffed.
She the driver or the passenger? Is there a co-defendant? Did someone else get the UUMV?
It does not appear there's any co-defendant.
It's a passenger.
Stop. Ma'am, don't.
All it says is that she got out of the suspect vehicle.
Ma'am, I'm going to find that there's probable cause to go forward with the case. If you do not have a Texas driver license, you are not allowed to drive. Do you understand me, ma'am?
Yes, sir.
Also, you need liability insurance if you're going to drive. If you don't have either, then you're not allowed to drive. You understand? Do you have the ability to hire a lawyer, or would you like a court-appointed lawyer, ma'am?
Court-appointed lawyer.
Okay, I need you to, let me see if I have an application. I need you to fill out an application for me. I'll take a look at it, and then we can appoint you someone later today. Do not leave until you sign our bond conditions, though, ma'am.
Yes, sir.
All right? Okay, please.
That's it, Judge.
Got it. You're Adam Reyes. Mr. Reyes, you're charged with racing on a highway. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On January 23rd, 2025, law enforcement officer observed a black Silverado and a white Honda Accord at the 7800 block of State Highway 6 turning left at a high rate of speed. The law enforcement officer made a U-turn at an intersection that followed both motor vehicles, having to travel approximately 66 miles an hour in a 40-mile-an-hour zone. The officer observed motor vehicles to be side by side with the Honda flashing emergency lights. The law enforcement officer observed Honda turn off the lights. Both motor vehicles began to speed up again while driving side by side, and they ran a red light. The officer attempted to catch up with both motor vehicles, causing the officer to travel approximately 90 miles an hour in a 40-mile-per-hour zone. The officer briefly lost sight and re-observed the Silverado as the motor vehicle continued traveling eastbound. Traffic stop was initiated. The officer made contact with defendant, driver, the sole occupant. The defendant stated when asked about high rate of speed, "No, I was on my way home with my friend Adam, and Adam was following me home." Co-defendant arrived claiming he was there to check on the welfare of the defendant. The co-defendant stated, "I was following them home, but I broke off because I wanted to get something to eat." Defendant ID'd with a Texas driver's license.
And Mr. Reyes, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to participate in this type of activity again. If I find that you do, I'm going to put you in jail, and then I'm going to take your ability to drive away. Do you understand? Can you look to see if he has a valid Texas driver license, please?
Yes, Judge, eligible.
Okay. Do you have the ability to hire a lawyer, Mr. Reyes, or did you want to apply for an appointed lawyer?
I'll hire one.
Okay. I'm going to have you sign a receipt, Victoria. I'll have you take a seat in the jury box while we get your bond conditions, while we sign it, and after that, you'll be free to go. Be safe in my city. Do you understand? All right.
This way.
Mr. Thornton, you're charged with assault of a family member. You're facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, the complaining witness and the defendant are in a dating relationship. And on December 18th, 2024, in Harris County, Texas, officers were dispatched to an assault call at a hospital. The officer arrived and made contact with the complaining witness, who stated that she and the defendant are in a dating relationship. The complaining witness stated that earlier in the day, she and the defendant were in an argument due to the complaining witness telling the defendant that he needed to leave the location. When the complaining witness got up to leave, the defendant pushed her through a wall, causing her to crash through the wall, causing pain. The officer observed the complaining witness to have a laceration over her right eyelid, swelling and bruising.
What's the problem in this case? You know, it shows it's dismissed. Something went wrong. Something's wrong. I'm showing that the case is dismissed when it shouldn't be.
Okay, this is Thornton, Judge.
Yeah. I don't know. I don't even.
This one was signed.
It is a DVD case,
Or
Judge.
Mr. Witness.
I don't even see a nollie.
It's not published, Judge.
Judge.
I mean, ready to publish.
Judge, you said you spoke with Chief Campbell, was dismissed for missing witness due to.
So it is dismissed then, right? Okay, your case has been dismissed, believe it or not. Just be careful out there, you know?
You seek to.
Well, that's it for today, everybody. Tomorrow is Judge J. Cedric Simpson docket. So you all have a wonderful evening. I will see you again soon. If you're not a subscriber to this channel and you like the content that's on this channel, please consider subscribing to this channel. By doing so, you are helping this channel grow. So you all have a wonderful evening. I will see you guys back here at 3 o'clock tomorrow. I had a doctor's appointment, but I got out early, but by the time I got here, it was 3. So I will be here at 3 o'clock tomorrow afternoon. You all have a wonderful evening, and I'll see you again soon. Ciao, ciao, ta-ta, and have a good one.
Never give up on this heart of mine. Put it back together every single time. Fix it all, fixing your I was standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's okay.